to pay the nearly $400 million bond needed to appeal the judge's decision in his New York City civil fraud case.
But you're looking at roughly, let's call it close to $400 million for something that he did nothing wrong. Look, it's no coincidence, and I'll say it. They know by looking at his statements of financial condition that this guy is worth a lot of money, billions and billions of dollars, and that didn't even include his brand.
Mark Smith is a constitutional attorney and former member of President Trump's transition team, and he joins us now. Mark, good morning to you. So the president is facing this massive fine. He's also barred from serving as executive of the Trump Organization for 3 years. Can't apply for a loan in New York for that period of time either, which would be a huge deal. You can't apply for loans at banks in New York when you're trying to run a business. What are the chances that he does win on appeal?
Well, I think the one thing we can say, Carly, is this is going to take a long time. And I say that because there's really no incentive for the New York court system to speed this along, because speed would be in Donald Trump's favor. I think he has actually a very strong argument on the merits, several different arguments, one of which is the classic definition of fraud, which even first-year law students are taught was not applied in this case. Now, that's because of the way this judge ruled the meaning of Executive Law 63 under the New York State Code says that a lot of those things that everyone understands fraud to be does not apply under the statute. And that's going to give rise to a very difficult legal question for the Court of Appeals in New York as to whether or not they're literally going to jettison, hundreds of years of jurisprudence as to what fraud means because of the way this particular New York statute's written. That's going to be a difficult question, because if you take the fraud out of fraud in a sense, then what you have is something much different. And if it's something much looser than what is fraud, then how do you justify these draconian penalties on any American, not just Donald Trump?
Everything you said, I 100% agree with. But going forward, you mentioned that there are a lot of big issues that can be appealed here. However, knowing Trump as well as you know him, are you a little bit worried that he is going to push his counsel to try and relitigate the case that was litigated at the trial court level, which, as you well know, you cannot do, instead of being laser focused on only the issues that can be appealed, which, like you mentioned, are plentiful and are ripe to be overturned?
Look, President Trump has good lawyers, and they're going to make every conceivable argument that they can, as well they should, because don't want to leave any possible rights behind. And they have powerful arguments under New York state law, but there's also potential constitutional arguments, Todd, along the lines of, is this a taking of property? Is this a violation of due process? The United States Supreme Court itself has specifically said that there has to be some connection between the conduct on the one hand and the penalties on the other hand. And if they become too out of line, you might have a due process violation. You often see that in the context of punitive damages cases. And I mean, if you look at a situation here, the huge amount that's been awarded against Donald Trump, but then you compare that with the fact there's really no victims here, no one was complaining. Usually you see the attorney general get involved where you have a line of, financial victims out the door complaining that someone committed fraud and cost them their life savings. You don't have that here. You have the most sophisticated banks on the planet saying, yeah, we like the Trump organization. We will do business with them again. That is a very inconsistent fact pattern than what you usually see in a fraud-related case by an attorney general's office.
Mark, real quick, his lawyers say he's prepared to pay the nearly $400 million bond. Why is the bond so high?
Well, usually the way it works is you can avoid, you don't have to pay the bond, but if you don't pay the bond on an appeal, it means they can start to execute the judgment, meaning they can go try to collect the money. So to avoid that, you want to post a bond. Usually the way it works, Carly, is that you post a percentage of the bond to a bank, and then if you lose in your appeal, the bank will pay off the full amount of the fine, and then you repay the bank. So yeah, what we're really trying to do here, if you're the Trump organization, is you're trying to stay any attempt to effectuate the judgment to collect assets right now by posting that bond. But usually you don't have to post the full amount of the bond. It's just a percentage of that. And then again, if you lose the appeal, you have to pay the full amount to the bank or to the other side. So that's kind of the procedural process that's going on right now.
From New York to D.C., special counsel Jack Smith pushing to get Donald Trump's federal election case to trial this year. I think all of these issues ultimately end up at the Supreme Court. So what is the normal timing for a case / an issue for the Supreme Court to decide on? And second part of that question, what is Jack Smith trying to do to override that timing?
Well, this is something I don't think has been focused on enough. Keep in mind that Jack Smith, the special counsel, just about a month ago was literally saying that the only court in America that should consider this presidential immunity question is the United States Supreme Court. Now that he's won in the D.C. Court of Appeals, he's basically saying to the Supreme Court, we don't need your help. Let the D.C. Court of Appeals issue stand, the decision stand. So what's going on right now, Todd? If you and I today sought certiorari to the Supreme Court today, the earliest conceivable date that we would be heard would be sometime this fall, after October of 2024. And what's interesting here is that will the Supreme Court try to expedite this case? But if there's any other litigant in the United States, there'd be no chance for you to have your case heard this spring, because really the docket is full up for this term. You'd be looking at next term, which starts in October 2024. But of course, Jack Smith, to the extent it goes to the Supreme Court, he wants it resolved now, because it's pretty clear that what the special counsel wants is a trial in front of a D.C. jury with a D.C. judge to occur immediately, because he feels, I'm sure very strongly, that Donald Trump cannot get a fair trial in D.C. given the political,
that's what he wants.
Political makeup of that panel.
Mark, thank you for joining us on the legalese of the morning.
Mark.
We're going to be watching it all and have you back soon. Have a great day.
I'm Steve Ducey.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.